All right, I guess we can start. Welcome back, everyone, to another book seminar where we discuss recent publications on international cybersecurity. This is organized by the Hague Program on International Cybersecurity. And today I'm very honored to have Professors Nicholas Tsagourias and Russell Buchan here to present the newest co-edited volume together with Daniel Franchini on the peaceful settlement of interstate cyber disputes. So I don't think that Russell or Nicholas need a lot of introduction, but nonetheless, I will just briefly say a few words about them. So Professor Nicholas Tsagourias is Professor of International Law at the University of Sheffield. He's also visiting Professor of International Law at the Paris School of International Affairs, Sciences Po, and a Senior Fellow at the Libo Institute at West Point. Russell Buchan is also a Professor of International Law at the University of Reading and also a Senior Fellow at West Point. And both of them are highly accomplished. They have written a bunch of books and articles on the subject of international law in cyberspace, and have also done a lot of edited volumes so far. This one is the most recent one on the peaceful settlement of interstate cyber disputes. I personally think this is a very, very important subject, and those of you who have followed the UN discussions know also this is a term, the peaceful settlement of disputes, that comes up all the time. So I'm very interested in hearing more about both of you, about that from both of you. So how this goes is we will have around 30 to 35 minutes of presentations by Nicholas and Russell, which will be followed by a Q&A. So any one of you who would like to ask a question, you can either do that by putting your question into the chat and I will read that out later, or you can also raise your hand and then turn on the camera if you want and then ask your question personally to the authors or editors. So thanks a lot again, both of you, Nicholas and Russell, for joining us today, and I'm very excited now for your presentation.
Well, thank you, Isabella. So I will start. I want to thank also the Hague Program for the invitation and for the opportunity to present our book. So what I will do, I will give an overview of the book and of the aims of the book, and then Russell will take over and present certain features of the book. So the idea behind the book did arise actually some years ago because of my frustration with the fact that the cyber discourse has been hijacked by debates about the application of the jus in bello, the law on the use of force, and the jus in bello to cyber operations. And also there has been some frustration by the fact that although the GGE and the open-ended working group, but also states have repeatedly said that the principle of peaceful settlement of disputes applies to cyberspace, there has been no further discussion or elaboration of how this principle applies to cyber disputes. And also there has been some recognition that more and more cyber has become a feature of interstate disputes, either physical disputes taking place in the offline world migrating to cyber, so having a cyber aspect, or having a purely cyber disputes regarding cyber operations. And this event has the potential of aggravating or disrupting international peace and security. So for this reason, with my colleague, Russell Buchan, who is present, and also Daniel Franchini, we decided to hold an international conference. We invited experts, academics, practitioners, but also diplomats. But unfortunately, COVID struck. So the conference was postponed twice, actually. So finally, we had the conference online. So the book derives from this conference. And the majority of the chapters are drawn from the conference, but the book includes also new chapters and authors. So the aim of the book, or the main aim of the book, is to consider how existing concepts institutions and methods of dispute settlement can apply to cyber disputes and address certain challenges that may exist. So the book was published in November 2024, so it's a very recent publication. It has 10 chapters. So the first chapter is written by me, and it explains when a cyber dispute becomes an international legal dispute by looking into the process of transformation of a dispute or disagreement by naming, blaming, and claiming. So naming that something wrong has happened, blaming another state, and claiming but also having a counterclaim. So if this process takes place by using international law language within the context of international law, so you have a disagreement that becomes an international legal dispute. And then I try to apply this definition to 4 scenarios and see whether there is an international legal dispute. So it is disputes over facts by looking into attribution, disagreements over points of international law, whether international law rights, duties exist, whether there's a breach of international law because of certain cyber operations. Disagreements in multilateral fora, for example, within the GGE, the open-ended working group, and then covert cyber operations and the legal issues they give rise to. So my finding is that at the moment, states avoid using international legal language when they want to indicate or to identify and condemn operations, malicious cyber operations. But there is the possibility, as international law develops and becomes more certain as to how it applies, that international law may be used by states. The second chapter is by Professor Robert Kolb and Dr. Andras Kastelic from UNIDIR, which is about the application of the principle of good faith to the peaceful settlement of cyber disputes, because the principle or the obligation of the peaceful settlement of cyber disputes, it is informed by the principle of good faith. So for them, it translates in the obligation to preserve the confidentiality of the process, of the dispute settlement process, the prohibition of aggravation of the dispute, so it's about the de-escalation of the dispute, the obligation to protect legitimate expectations, and the obligation of disclosure. The third chapter is written by my colleague, Dr. Daniel Franchini, and considers the role of domestic courts in the settlement of cyber disputes. So for him, they play actually 2 roles. One is as gatekeepers by ensuring that state policies, actions, legislation are compliant with international law by applying domestic law, which translates international law within the domestic system. And then there's the external aspect of the role of domestic courts by taking action against individuals, state officials, or private cyber contractors involved in malicious cyber operations. So there are indictments against foreign nationals that were involved in malicious cyber operations, in espionage, or any other malicious cyber operation. The 4th chapter is written by Professor Konstantin Antonopoulos and discusses the role of the International Court of Justice as a forum for settling cyber disputes. So he argues that because of the features of cyberspace, that they facilitate anonymity, for example, this can raise questions of jurisdiction of the court. For example, whether there is actually a dispute, in particular if someone thinks also of the issue of attribution. And also issues of admissibility, because cyber operations, because of the interconnected nature of cyberspace, cyber operations may have effects or on different states, on many states, but not all the states may be present before the International Court of Justice. So that gives rise to what's called the monetary gold principle, meaning that the court cannot adjudicate a case if, in order to decide the case, needs to decide on the legality of the acts of another state. So that it dismisses the case. So there can be other issues. There can be issues of legal interest. So in order to bring a case, a state needs to have a legal interest. However, if there are states with more states with a legal interest to a particular cyber operation, the ICJ can join the cases and can deal with all the cases together. But the ICJ can also play a role, an important role, through its advisory opinions, and advisory opinions can play, if you like, a more constitutional role by identifying the law that can apply to cyber operations, by identifying the obligations of states. The next chapter is by Dr. Annegret Bendiek, Martin Müller, and Professor Matthias Kettermann, and focuses on the European Union and its internal and external cyber policy as a mechanism to prevent or settle internal disputes among EU member states, but also contributing to a rules-based environment, external environment. This is about the normative effect and the regulatory effect that EU law can have outside the EU context. Some they call it the Brussels effect. But beyond that, can be an example of regional cooperation and contributing to the normative and regulatory development of international law in cyberspace. The next chapter is by Tomohiro Mikanagi, who is the legal advisor to the Japanese, his legal advisor to the Japanese Foreign Ministry. It's about the role of the UN Security Council in the peaceful settlement of interstate disputes. So the Security Council can determine as to whether there's a threat to the peace, a cyber operation constitutes a threat to the peace, a breach of the peace, or an act of aggression. It can take measures, can take forcible, non-forcible measures like sanctions, and to extreme circumstances take forcible measures. But even if it is not able to do that, because of issues of attribution, etc., it can condemn states for certain cyber operations, or condemn non-state actors for malicious cyber operations. But also it can condemn malicious cyber operations as such. And in this way, it can identify what is expected, what is the expected responsible behavior by states in cyberspace. The next chapter is by Ambassador Dr. Iakovos Iakovidis. It's about the role of cyber diplomacy or diplomacy in certain cyber disputes, and he looks at the role of diplomacy in bilateral settings between states, either formal or informal settings, for example, dialogue between US and China, US and Russia, etc. Within regional settings, the Organization of American States, for example, the EU is another example, the African Union, but also the global setting. For example, the GGE, the open-ended working group, the ITU, that they contribute to the identification, clarification of norms of behavior, what is called responsible behavior in cyberspace, and de-escalating disputes through communication. The next chapter is written by Professor Joanna Kulesa and focuses on the EU and how it approaches interstate data disputes by exercising extraterritorial jurisdiction or through what is called the Brussels effect. And then there's a chapter by Professor Paul Ranker from Stockholm University, who claims that states should use all the available mechanisms of dispute settlement, but stresses the importance of arbitration, mainly because arbitration you can have specialized, because cyber disputes have a technical aspect and then it's specialization. So with arbitration, you have experts, special people with special knowledge, and their decisions, the awards, are binding on states, so they can settle the dispute. Of course, there are problems with evidence and the production of evidence because the standards for arbitration are quite high. Conciliation is another method, which is important because it is not very much dependent on law. Conciliators can go beyond the law. So it's between diplomatic and legal methods of dispute settlement, but also they can suggest and propose positive action or measures, confidence-building measures before, during, and after the process. So this is a very important method. And then fact-finding or inquiries for settling cyber disputes. So now I will pass over to Russell, who is going to present his contribution to the book, but also say a couple of words about the book. So, Russell, over to you.
Thanks very much, Nicholas, and obviously thanks to the Hague programme for giving us the opportunity to launch our book with you. So the careful reader will notice that there are 10 chapters in the book, and the careful listener will notice that Nicholas described gave an overview of 9 chapters in the book. So the one that is missing is my one. So, that was deliberate. And the aim is for me just to give you a bit of a taster of what one of those substantive chapters look like. And my chapter is on the very important and topical question of collective and third-party cyber countermeasures. So let me just say a few words about the chapter and flag my findings, which I think, perhaps are quite controversial and may generate a little bit of discussion. As we know, countermeasures is very well established as a doctrine in international law and on state responsibility. It's reflected in the articles on state responsibility and in jurisprudence and state practice and so on and so forth. But it's also a method of peaceful dispute settlement. Firstly, because countermeasures cannot involve the use of force, as we know. But secondly, perhaps as importantly, countermeasures are designed to restore international illegality. So when one state acts unlawfully towards another state, the victim state or the injured state can act in a prima facie unlawful way in order to pressurize the wrongdoing state into complying with their international legal obligations. And countermeasures are often bilateral in nature. States will owe bilateral obligations towards other states, where they breach those bilateral countermeasures will be available. Over time, as we know, and the ICJ was a key driver of this development, as well as other institutions. International law has developed a multilateral structure. And what I mean by that is that there are certain obligations out there that states owe, which they don't just owe bilaterally towards other states, but which are owed to either the international community writ large, obligations erga omnes, or to a number of states together. So obligations erga omnes partes, often in the context of a treaty. There are some provisions of that treaty which are owed to all of the members because they protect certain community values and community interests. So we're all familiar with those types of obligations, and it's, obligations erga omnes, it's the big ones, the ones that protect international peace. So Article 2.4 of the UN Charter is owed erga omnes. Certain human rights obligations, self-determination, a breach or an interference with those rights, those obligations, implicates the international community as a whole. So the question is, when there is a breach of one of those obligations, or obligations erga omnes or omnes partes, as to what is the legal recourse of other states in the international community. Well, Article 48 of the Articles on State Responsibility makes it very clear that states can invoke the responsibility of the wrongdoing state, even though they are not directly injured by that particular breach, but because they form part of the international community as a whole. So when Russia invades Ukraine, there's a breach of Article 2.4, Ukraine is directly injured, but the international community generally is indirectly injured, as we call it, because there has been not just a breach of Article 2.4, but it undermines international peace and security, which is a community value and requires community protection. But then there's a second question, as important, which is whether or not the international community as a whole can take countermeasures in order to enforce the responsibility of the wrongdoing state. So Article 48 says you can invoke the responsibility, so you can call upon it to comply with its obligations, you can demand cessation, non-repetition, etc. But there's a second question as to whether those states can take countermeasures to enforce responsibility. So this is a doctrine known as collective countermeasures. So countermeasures taken by other states in order to protect collective interests, community values. And for those of us that know anything about international law, we will be very familiar with the long debate that the International Law Commission, I think James Crawford, the special rapporteur, said it was one of the most contested, difficult issues that they had to face. It was discussed quite at length over many years by the International Law Commission, and in a very anticlimactic way, their conclusion was, as reflected in Article 54, we don't know. And it's referred to as a saving clause by the United Kingdom. And the International Law Commission said, we're just going to leave collective countermeasures to the development of international law, and we're just going to put a placeholder there with Article 54. So the matter was left very much unresolved. And it was to a certain extent a subject that laid a little bit dormant post 2001. Perhaps other international events at the time took over. But the dawn and the advent of cyberspace has really brought collective countermeasures back to the fore, really being started or triggered by Estonia in 2019. I remember I was at the SciCon conference where the president furthered the position, not quite sure what that means, but furthered the position that collective countermeasures were really useful in cyberspace and could help prevent cyberspace becoming this Wild West, as I think President Obama referred to it, and were actually established in customary international law. And of course, I can see the intuitive appeal to that. If you have a big state, I imagine perhaps Russia, threatening a smaller state, perhaps Estonia as a neighbor, and conducting cyber operations, malicious cyber operations against it, then it could be in those smaller states' interests, and perhaps in the larger states as well, that are looking to respond to international equality, taking collective countermeasures against the wrongdoer in order to heap pressure on them to discontinue their unlawful cyber operations. Of course, there are kind of policy risks that come with that. It could be potentially destabilizing. I think there are equities on either side. But really what I try to do in the chapter, I flagged those. Of course, you can't avoid those. But, this really is, my chapter is very doctrinal. And it really looks to, putting the policy issues to one side. And as a matter of customary international law, is the doctrine of collective countermeasures actually established in state practice and opinio juris, which, as I say, is a question that the ILC Delphically avoided in 2001. So I did kind of a real deep dive. I'd hope that when you read the chapter, you might find it a bit boring, that I go through state practice after state practice after state practice. Good, that's exactly what I wanted to do. Because there is some scholarship out there that kind of, I think Jean Dasseron calls it custom on the dance floor, that anything constitutes dancing if you just throw your arms in the air. I feel that's with collective countermeasures, because there are some commentators say this is collective countermeasures, this is collective countermeasures, and therefore the ILC got it wrong, and there is evidence in favor, or widespread state practice coupled with opinion juris in favor. And you start looking down into some of those examples, and I don't agree, and I tried to demonstrate that there may have been multiple other grounds on which states took measures against a wrongdoing state in order to try to encourage it to change its position. So let me give the obvious example of sanctions. Over the course of since 1945, many states have adopted sanctions against other states because of their poor human rights practices. But, are those sanctions countermeasures? Well, if you look into it, then, it's likely that they're not. Why? Because they are not in themselves prima facie wrongful. They are basically examples of retortion, not of countermeasures, let alone collective countermeasures. And therefore, it really, undermines the argument that there is this aggregation of state practice in favor of collective countermeasures. And even on the cyber side, so I'm going to look at my teaching slide now that I use for students, and I basically list all of the state positions that have been expressed and articulated in the national cyber statements that we're all very familiar with. And again, I feel that there's in the cyber international cyber law world, there's a slight misrepresentation of the direction of state practice in those cyber statements. Yes, there are states that are now advocating in favor of the customary international law status of collective countermeasures, and in particular how they apply to cyberspace. And some states have clearly changed their mind since 2001, when they were giving feedback and responses to the International Law Commission. There's no doubt about that. However, critically, there still are a number of states that are very uneasy with the doctrine of collective countermeasures. So France unambiguously rejects collective countermeasures. Canada unambiguously rejects collective countermeasures. Other states are a bit more on the fence. I've already mentioned Estonia's language of furthering the position, which I'm not quite sure if that's kind of a strong showing of opinion juris. New Zealand says that it's open to the proposition of collective countermeasures. Again, not an all singing, all dancing example of a state being in favor of their customary international law status. And there are many states that have continue to refuse to opine on this. So the African Union completely sidesteps the doctrine of countermeasures and collective countermeasures. And for me, I'm a fairly inductive person when it comes to the sources of international law. I maintain that threshold for custom at quite a high level. You need widespread, representative, consistent state practice backed up by a clear opinion juris. And looking back at, say, the non-cyber state practice, but also the cyber state practice, for me, it's far too contested, divergent, to establish itself as a foundation on which to build such a legal doctrine. So when it comes to collective countermeasures, I take the position that it's yet to, basically it's similar to as it was in 2001, that the landscape is still too contested to establish this customary international doctrine. And I'll just finish on the point of third-party countermeasures. So I think this is another benefit of the chapter, is that I distinguish between collective and third-party countermeasures. So critically, collective countermeasures are those that are aimed at protecting erga omnes or erga omnes partes rules, so protecting community values. What about the situation, as I discussed at the beginning of my remarks, where one state, state A, owes bilateral obligations towards state B? It's a pure bilateral obligation. There's no erga omnes, there's no erga omnes partes. It's just, one state breaching its obligations towards one state. I just threw my pen on the floor. I'm getting excited now. And forgive the noise. In that situation, can the injured state, state B, invite all of its friends to take countermeasures against the wrongdoing state, state A, even though, as I said, there's no collective rule, collective interest or erga omnes or erga omnes partes rule involved. And I find even less evidence of state practice to support that. And you may be making the analogy there with collective self-defense, saying, well, perhaps under Article 51, if a state has a right to invite other states to come to its defense, then perhaps an injured state also has a right to request assistance from other states, even in the absence of an erga omnes or erga omnes partes rule. I've seen that in the literature as well, kind of a shortcut to getting towards the permissibility of both collective and third-party countermeasures. I find that that's an analogy that breaks down at almost every stage, not least because collective self-defense is about self-preservation of the state. So of course, if I've been subject to grave violence and armed attack, I can request others to come and help me. I don't think anyone would dispute that. But if I have my legal rights infringed, do I have the right to ask others to come and help me protect my legal rights? That's a law enforcement paradigm, very different from the self-preservation, self-defense paradigm. So yeah, I think I'll conclude there that the headlines are both on the collective countermeasures and the third-party countermeasures that have traction and importance in cyberspace. I find that the state practice in the opinion juris isn't there in order to establish those doctrines as a matter of customary international law. I'll hand out back over to you, Isabella, as I realize I'm out of time.